Okay, so I'm understanding, okay, the initial probable cause affidavit is part of the public record. And you're saying, well, that got spread, okay, by the media, as you would expect. And that's something that could be concerned. So what I think maybe, I don't know, what Mr. Thompson is talking about though is information or questions that were not in the record. And so what I'm nervous about this is I don't want to continue to spread things out that shouldn't be spread. And so I don't know what's in the slides, but if there's information in the slides that are not in the public record, that really have not been disseminated generally, then I mean I don't really want to spread it. None of us want to spread it more than necessary.
Well, last week in court, that was right inside the courtroom. That all became part of the public record. The 9 questions were stated repeatedly in different formats by Mr. Thompson. That's part of the public record. We've been accused of violating the non-dissemination order. Dr. Edelman's reputation has been impugned by what was stated about him repeatedly. Those questions are fair game. But having this hearing and allowing our expert to talk about this process, that's not the problem. The problem with the media happened a long time ago, and it started with the sharing of the affidavit far and wide.
I understand that. I'm pulled in 2 different directions right now because I'm trying to protect your client at the same time. So if we keep talking about this, what is not true, okay, I mean, I guess we can just say, well, it's not true on some of these questions. Maybe that helps to reduce bias. But if we don't make that clear, then it could increase bias. I think. I don't know, tell me, maybe I'll hear this from the expert.
I'm going to say it like this. Mr. Kohberger is my client, and his rights are of the utmost importance to me. Him being treated fair, his presumption of innocence, him having an impartial jury, those are important things to me, as is his right to counsel. I am not standing up here saying, let me tell you about this survey. Let me finish this survey to hurt him. I'm saying there is pervasive media coverage in this case. It's prejudicial media coverage. We've conducted a survey in Latah County. That survey is going to show bias and that you shouldn't have a trial in this county. What I'm trying to do is say, do you want me to give you information about another place where maybe the bias isn't so great, where maybe Mr. Kohberger can have a fair trial? I'm his advocate. I want to help him. I believe in his innocence. I'm not going to stand in this courtroom and do anything wrong to him at all. I need you to hear the information so you can make a decision, to have the surveys, to have the information when we come back here for change of venue and make a decision on all of the information. Right now, if we come in and do our change of venue, we're going to say you can't have this jury in Latah County, but I can't tell you a better place that will protect him better. And that's what I want to do.
Any response, Mr. Thompson?
We aren't here to argue about venue today. We aren't here to argue about what this particular survey with the loaded questions, fact-loaded questions, may have produced in Latah County residents. As we mentioned last week, the structure of those questions assumes that every person that is called has heard all of the media in this case. And we know that that just simply isn't true. So for those citizens in this county who have not heard all of the rumors, who have not been following the media, who haven't inspected the court record, who are essentially ignorant of facts in this case, well, that's just been jaundiced by the questions that were asked. They have now been force-fed facts, some of which are not true, some of which would not be offered in court, and in fact, probably wouldn't legally be admissible in court, to somebody who may never have heard them before. That's the state's concern about the way this thing is put together. And the arguments from the defense seem to be completely ignoring that point. That there are people out here who don't know all the things that they were being asked. And by asking the fact-specific questions, we were inoculating them with information that they didn't have before about this case that could affect their ability to sit as jurors. It's just simply irresponsible. It doesn't make sense.
Listen, this is one of the things that I was thinking about is maybe we can inoculate by saying you can't rely on any of this information. It's not established by evidence. It's not been provided in court. But to just send a message out to be clear that these questions have nothing to do with guilt or innocence or even truth.
But that's not what was done, Judge.
I know. We have to fix this in some way.
Yes, sir.
That's what you said last time. And so I just want to help the public understand that this is not the trial.
Your Honor,
Yes.
at this rate, we may never get to trial. We know this isn't the trial. We brought Dr. Edelman to talk about the process, which will answer the state's concerns about this process. He hasn't even had a chance to tell you how this is constructed. He's the one that's the doctor of this kind of work. He's the one that's the professional. He's the one that knows how to do this. He's the one that spent his career understanding surveys and how to construct these. You need to hear from him. Going back and forth between what Bill thinks and what I think doesn't matter. What matters is you hearing from the expert to make a decision. He's here, he's ready to testify. We're 20 minutes into this hearing and he hasn't been allowed to take the stand yet. He came to inform the court about this process.
Well, there's no question I'm going to let him testify. I just wondered about what's in this. I haven't looked at this, but it's you're comfortable having this come out into the public?
Yes, after last week's hearing, absolutely.
Okay, and you looked at it, Mr. Thompson?
You have concerns,
Is it
Judge.
alarming?
Well, part of what's in there is a part of the survey study being published now, if this comes to the public, without any comparison to anything else. And it's the product of these loaded questions. It takes us back to the fundamental issue of how this survey was conducted and the assumption that the people who were being called already knew all this stuff. And so it didn't hurt to specifically ask them, have you heard about such, the specific item? Well, if they hadn't heard about it before, they sure as heck have heard about it now. That's the core concern that led us to this in the first place. We don't dispute the defense doing a survey. I said that last week. Please do a survey, but don't go around screwing with the knowledge that prospective jurors have or may not have. That's our concern. And, Your Honor, when we parted ways last week, the court said, Ms. Taylor, talk with Mr. Edelman and see what the options are. Well, my understanding from the email I received the day before yesterday is the survey cannot be changed. That was from Ms. Taylor reporting what Dr. Edelman said. I interpret that as they don't want to change it. Anything can be done, but that's where we're left. I would have been happy to engage in discussion with defense about maybe some middle ground, but the line has been drawn black and white. I am concerned about the specific things that relate to venue, partial survey results that are in this PowerPoint. I believe it is premature for them to come out now. The rest of it is fine. Let's bring it out so that you have whatever information you want. You can give it the weight that you decide. I just didn't want to let this willy-nilly come into the public record in a half-baked fashion.
I have lots of concerns. We're not left with this because I have to make a decision about several things.
Yes, sir.
And so in order for me to have the most informed, decision. I need the information, so we're just gonna go ahead. All right,
Thank you.
and you can show your slides, and if something is concerning, we can talk about it along with it. All right,